what y'all are. Frankly, that's all y'all are. Y'all like seeing men, all your own men suffer. Look, you probably a lesbian yourself, ain't you? You don't like men either. All y'all like that. All y'all don't give
Okay, buckle up, everybody, because we are about to watch the parole revocation hearing for a man who, well, he's choosing to represent himself, which in the state of Connecticut, it is a big mistake because they give you attorneys for these parole revocation hearings. And these attorneys, from what we have seen, are actually quite impressive. But you see, this isn't the first time that this man has chosen to represent himself. As a matter of fact, he was convicted of a bank robbery when he also chose to represent himself in front of a jury. And one of the lines that he said to the jury, it's quite comical, I think. He said, "Well, jurors, what do you feel about bank robbers? Do you support them?" They all said no. And his next question was, "Well, what about attempted bank robberies?" As if that was going to be a mic drop. Now, of course, the jury found him guilty. And as the famous Abraham Lincoln quote, what is it? The man who represents himself has a fool for a client. I don't think it could be any more true in this parole revocation hearing. Now, that bank robbery, that was just one of the crimes that he has committed. He's got a whole lot on his record. Thank you, Holly, for pulling this up. But he's got criminal trespassing. He has, I mean, it's not his first trip at the rodeo. And just you got a taste of how this hearing ends up. But let's go through the process. And I'll tell you, by the way, that this is not going to be the last that we see him. This is just a preliminary hearing, so we're going to see him again. Make sure to check the description. It's possible there is a return of, so make sure to check the link. If it's not there yet, it'll be coming soon. Now, with that, let's jump.
You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
I would like to proceed without counsel.
Okay, thank you. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state, your parole officers, bringing against you and the information underlying each charge. Charge 1, obedience to the law. On January 13th, 2025, you went into the street and walked upstairs to the Sierra Center halfway house on the 4th floor. You were previously prohibited from the Sierra Center halfway house and its premises due to intimidation and threats that you made toward a Sierra Center halfway house staff member. Due to your actions, Connecticut State Police issued a warrant for your arrest for criminal trespass, stalking third, breach of peace with a $25,000 bond. Charge 2, search. On January 17th, 2025, parole staff instructed you to sit in a chair in order to search your shoes. You refused to have a seat in the chair. You also refused to remove your shoes. This violates your special parole conditions that state I will submit to a search of my person, possessions, vehicle, residence, business, or other area under my control at any time, announced or unannounced, with or without cause, by parole or its agents to verify my compliance with the conditions of my parole. Charge 3, no consumption of alcohol. On January 17th, 2025, you rendered a urinalysis. Your specimen number P3482418 was sent to Premier Biotech Labs for alcohol testing. On January 22nd, 2025, Premier Biotech Labs confirmed that your specimen was positive for alcohol. The state has filed the following exhibits. Exhibit A, Statement of Understanding and Agreement Conditions of Parole. Exhibit B, Remand to Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Notice of Parolee Rights. Exhibit E, Parole Violation Report. Exhibit F, decision information summary. Exhibit G, Connecticut State Police arrest warrant. Exhibit H, Connecticut State Police report. Exhibit I, the Connection Sierra Halfway House incident report. Exhibit J, notice of parole violation. Exhibit K, Premier Biotech Labs toxology report. Exhibit L, offender misconducts. And Exhibit M, revocation summaries. Mr. Riles, did you receive the notice of parole violation report, and the marked for identification purposes? It should have been like a parole package of evidence. Did you receive that?
After the continuance of this, my original preliminary hearing was scheduled on the same day as my court date. So on the 5th, I got that package. But the original notice of violation only had the one charge. I understand that urine took time to develop, so that's understandable. The other charge of refusing to let them search, I was in cuffs, I was in their custody. Technically, I was in the state police custody because he read me my rights and said.
Well, Mr. Riles, you're going to have an opportunity to testify. I just want to know if you received the evidence.
All right, yeah, after the original preliminary hearing court date, yes.
Okay, and you do have time to review it?
Yes.
Okay. And today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However,
Right,
remember that
excuse me, you said we have no witnesses. I did write on my first notice that Ed on was a witness because he was I got him the job where we work, and he was working with me along with another person. So I said on the first notice that they had his phone number because we both report to the same parole office, and I put him down as my witness.
Okay, one moment. So would you like him, what would be the purpose for his testimony?
To verify that what we were doing that day is distributing pamphlets, because we both work for Full Citizens Coalition, and I went to every public library in New Haven and every halfway house. I had just left. I went to Project Moore as well to drop off the pamphlets on 8th and Walter Brooks, a halfway house I went, which I discharged from originally. And then when I went to Sierra, he was in the car along with another resident, a resident of the halfway house of Sierra, and another coworker. So I had two coworkers in my vehicle when I went into the building that could verify that we were only there dropping off, because we do reentry now at my organization, and we have pamphlets for the clients there in case they want to call us for resume, job training, and things of that nature.
Okay.
So I wanted him to attest to that.
Okay. And you do not have his phone number?
No, that's why I put on the paper that Officer Ruiz, because she's his parole officer as well. She knows his cell phone number. All I know is because of the technology now is we don't memorize numbers no more. We just see names. So I don't recall his number.
So I'm going to just take a quick recess before I move forward, because so today you still like him as a witness today for this purposes of this hearing?
Just to attest to the job duties that we had at that day, because that was the reason I was there.
Okay, so I'm going to just take a quick recess, okay?
All right.
Back on record. So I just want to let you know that I did hear what you said today. I am taking it into consideration regarding your request for the witness. However, I'm not going to accept the witness for the following reason. Because your witness is regarding charge 1, obedience to the law, as to why you were at the halfway house, correct?
Yes.
Regarding charge 1, obedience to the law, on January 17th, 2025, a judge of the state of Connecticut Superior Court determined that there is probable cause to believe you committed the following offenses: criminal trespass first, stalking third, and breach of peace second. Therefore, I cannot revisit this finding. So regarding today, I was only going to take your testimony regarding charge 2, which is search, and charge 3, no alcohol, because a judge already established probable cause for charge 1. So testimony today will not be considered for charge 1 because probable cause was already established on January 17th by a judge.
So, this is why I didn't get an attorney, and this is why I'm doing this myself, because I have a $25,000 bond for this probable cause. There was no restraining order. There was no parole condition that I signed that said I can't be there. The last time the so-called victim, since they want to call her a victim, I'm gonna acknowledge that. The so-called victim saw me was 26 months ago when she got me arrested for threatening to inform.
Mr. Riles, what I'm trying to say is regarding charge 1, we can't revisit this finding. So your testimony as well as your witness you wanted to provide, the probable cause was already established. So regards to even your testimony today, it's already established. So we're not going to revisit that finding. So in terms of revocation, if we go the revocation route, absolutely, at that time it would be taken into consideration. But in terms of for the probable cause today, the preliminary hearing, testimony is not being taken into consideration. Okay. Because probable cause was already established for that one charge. But regarding charge 2, search, and regarding charge 3, no consumption of alcohol, you can absolutely testify to that today.
Okay.
Would you like to testify to those 2 charges?
Yes, ma'am.
Okay, it's your time to do so.
I had a report date of January the 16th. That day when I went to Sierra, one of the coworkers was called by one of the staff members from Sierra about my appearance there, and he suggested I don't go back because they were trying to lock me up. So this was Monday the 13th. Thursday the 16th, that was my scheduled report day. So I'm thinking that because of the situation, the misunderstanding at Sierra, that they were going to book me or remand me anyway. So that Wednesday night, I had a final good meal at a restaurant with a girl, and I had wine with my steak, New York steak to be exact. And that's because I thought Thursday they was going to remand me for this misunderstanding. However, come Thursday, I was only given a misconduct ticket that I signed for going to Sierra, even though I didn't understand why I was getting a misconduct, because I was not legally prohibited at that time to not be in that building for the scope of my job duties. I could see if it was a trespass or I had no business there or purpose there, that's one thing, but there was no restriction preventing me from going in that building or even around that person. However, I signed a misconduct because I didn't think, I thought I was gonna get remanded because, normally they don't care. They just remand you and that's that. So that's why the alcohol was in my person, because I thought it was, I'm Muslim, I don't even drink. I just had wine that Wednesday night. But the search and seizure, that I was already in custody. As soon as I went through the metal detector, they tricked me, I didn't even think I thought I was good because the day before I just got a misconduct. That seems to disappear from the evidence that they presented because I signed that. That was my initial punishment, and the punishment was frequent report date. Like I would have to report weekly, even though I've been doing extremely well, which I kind of argue because it didn't make sense, but then again, they do what they want. So when I went across the threshold, I was pounced on, they put me against the wall, cuffed me, went in my pockets, went in my back pockets, my side pockets, my hoodie. I gave my leather coat to P.O. Ruiz prior to even entrance because I didn't want to go through the metal detector holding that, so she carried that. So once they put the cuffs on, checked all of my pockets and stuff like that, the state police officer came and read me my rights. And when I heard my rights, I went crazy. I got in a panic attack because this is a misunderstanding and some frivolous charges. So after voicing to them that my chest was hurting, they wanted me to sit in a chair. I said it would be better if I lay down. They wanted to go on my sneakers. I said, you can go on my sneakers. I'm not stopping you. I'm cuffed. I can't stop you. I can't stop you from doing anything you want to do to me, including bringing me to jail. So I guess they got mad and threw that in late because the original charge was just the obedience of the law charge, which is charge 1. That's the first paperwork I got when I got in Whaley Avenue. They didn't have that issue about me not letting them search my sneakers. I can't prevent them from searching my sneakers, Miss Saunders, if I'm in their custody, cuffed up. I wasn't going to kick them. I wasn't wilding and being physically resistant. I just laid. I told them, put me down on the ground, my chest hurting. I'd rather be civically disobedient right now until the EMTs come. They came, and that was that. So originally that charge wasn't there, but I can see now that Harrison didn't want to throw it, whatever at the ceiling and whatever sticks. All I want today, the reason I didn't take a lawyer, Ms. Saunders, is because I'm not trying to make a sophisticated argument to you. This is about the truth. You just told me I can't even argue charge 1, which is blowing my mind that I can't. Because I'm not copping out to those charges. I told the judge that I want a speedy trial. I'm representing myself. I want to challenge my accuser because this is all stems from my first conviction with this woman of threatening too, which I only threatened to inform her staff that she was sleeping with clients. I was messing with a staff member in that facility. So because I was messing with a case manager, I knew who everyone was messing with. So once I stopped messing with that case manager, Ivy Collins, I still knew what's going on in the facility. Now, when she was trying to arrest me, I told her, if you jam me up for this frivolousness, I'm reporting you to your staff about who you're sleeping with. That was my threat. My threat was never physical, as you read in the exhibits from Connection, her incident report. You trying to jam me up and send me to jail? I could jam you up too because I know stuff.
Mr. Rouse, sticking to charges 2 and 3.
All right. So, but I'm only saying this to segue into why I need to be free while I'm fighting this case. Because one, my job, I'm the lead organizer of the state for Full Citizens Coalition, which is a Connecticut-based action group focused on undoing the unjust harm caused by felony disenfranchisement and ensuring that all citizens are respected as full citizens. That's our mission statement. I'm in charge of maybe 3 or 4 guys. We have an office in Hartford and an office in New Haven. I'm in the New Haven office on 1 Street. Now, the DNR, which I feel is not warranted because of the frivolousness of these charges, is preventing me from 1, doing my job. 2, I have a vehicle out there that's parked. I don't even know how long it could be parked or where it's at. I own it. It's registered. It's insured. I have my license. I was currently living in a parole house, which is like an apartment efficiency where you're not monitored. You basically have a key, bathroom, kitchen. That person loves me who runs the house, Roger Hines. He's holding my stuff as far as my clothing and all my property that was in the apartment. My bond is $25,000. I could have made bond the day I got arrested because that day I was picking up a check for like $1,800. Plus, my job is waiting to bond me out as we speak because I have work to do, and this is the misunderstanding, which is sad that I can't argue that with you, but I get it. The judge has supremacy over the decision makings for probable cause according to your system of adjudication. I get it. I just want, because of the nature of these charges, and it's not really, I'm pretty sure, even though I can't argue charge 1, you've read. You're familiar with charge 1 and the background involving charge 1. I never threatened her physically in the beginning. So for her to exaggerate any type of physical threat by me,
Mr. Riles,
I'm going again into charge 1. I'm sorry, but I'm pretty sure you've deduced that it was a misunderstanding And right now, they put a protective order on me, which I didn't even challenge. I didn't even show up to court because I don't care. There's a protective order with me and Miss for I got to stay 100 yards away from her. What else they did?
Okay, so regarding search and alcohol, regarding search, you keep going back to the number one, staying away from number one. We can't argue it. All right. So charge 2 and charge 3. If there's nothing further you have to say regarding charge 2 and 3, I can go into my findings. But if you're going to keep going back to charge 1, you can't do that because, like, again, the judge already established probable cause. But again, if we go the revocation route, you can 100% bring all of these arguments to the revocation process if we go that route. Because again, for probable cause purposes, it's already been established. Okay.
Okay. So, am I allowed to argue for why the DNR should be lifted, and I can make bond and go back to my apartment and go back to my job and fight this case, which eventually will be thrown out before I pick a jury?
Only regarding charges 2 and 3, search and alcohol, and the severity of these 2 charges.
Got you. All right.
Yeah.
So I go through the search and seizure. They've always had authority to search my person, my car, and my apartment. They always have, and I've never given them an issue about it. Every time I go into parole for a meeting, or when I'm scheduled to meet with my parole officer, I go through the metal detector. I take everything out. It's never been an issue with that. I understand they was upset with me because I was upset about these charges, and they're just throwing whatever they can throw. The alcohol, I told you, it was the night before. I don't drink. I'm Muslim. I think I had 2 dirty urines for alcohol in the whole 3 years I've been home. And that other one was because I didn't have any marijuana and I had a nip. I don't drink. And I've taken countless urines at the Project Morehouse, Roger Emerson House apartment that I stay in. We have to take urines whenever they want there, just because we're there. So I take urines with parole when I go see them every month, and I take whatever subjective urines Roger want to do with us. I follow all curfew. I've never brought in any females because we can't have company. I follow all rules there. He can attest to my behavior at that place. That's regarding the alcohol. The search and seizure, again, that I just think they just throwing whatever they could throw because that's not even a big deal. When I went to Welly Avenue, they took my sneakers. They were Jordans, and we can't even wear them in jail, and I had them sent to my job. I just want to be able. I'm 48 years old. I've been incarcerated for the last 17 years. I've spent 17 years in prison. If you add up the 15 I did and the times they bringing me back for these frivolous things with these cases, because as you can see, my criminal history has definitely changed because I went from drug charges, gun possession, federal cases, bank robbery, to miscellaneous charges like misdemeanors. And the other ones have gotten annihilated. My infraction got annihilated at the last halfway house, which they didn't even put in the evidence that the person took my charger. And I was being discharged to the Roger Emerson house, which is the parole house, the apartment I live in, the following day. So the person that I was living with took my charger and wouldn't give it back. Got aggressive with me. None of that's put in there because it's always designed to make me look like the bad guy, Miss Saunders. I've been out a total of 1 year. If you add the time I've spent on my own in the last 17 years. I'm not a threat to society. I don't tote guns. I don't gangbang. In fact, my job, we go against community violence. We work with community violent prevention on Aspen Street off of Dixwell. I'm in the city doing things for the community because that I feel like I've done nothing to the disenfranchised population of my community my whole life. I've added to that property, the valuing of our society. Now I finally got a job to give back, and I'm doing that, and I love my job. I'm getting $22 an hour. I saved $3,000 at the Roger Emerson house to put a security deposit on my own apartment when that time was up. I don't feel like I'm willing to go on a bracelet if I have to for a certain amount of time. I just want, my company is ready to bond me out. I didn't understand why the DNR was given to me for such charges like this when it's not a I'm not a threat to that building. I'm not a threat to that person. I haven't been a threat to anybody. Everyone wants to try to make me, Miss Saunders, out to be this violent person because I speak up for myself, because I believe in my own intelligence. because I'm not a slave to the state and I have to behave a certain way to where I was appalled that they even gave you the exhibit about parole when they came to see me in 2019 about parole. I think it's called Decision something. Right, all that was just to misnomer me in your eyes and put some type of cloud in your eyes so that you could say, oh, don't give this guy a chance. He's a piece of shit.
You are trash, Lindsay. You are trash.
I'm saying to you, Miss Saunders, I got an apartment still waiting for me from a guy who runs the apartment that can back me and attest to my behavior at that apartment, that I'm one of the best residents there. I have a job. If I could, you can call my boss right now. They'll pay for my bond. And I can fight this case on the street, which is, I feel, because of the severity of these charges are extremely minimal. And I don't have a history of going on the run. Like I said, I was told to report on Friday, even though Thursday on the 16th, they gave me a misconduct and the situation was over. But apparently the judge, during a 5-day span from January 13th all the way to the 17th, decided probable cause. I feel as though because I'm not a threat to nobody out there, the protective order's already, I didn't challenge it because it's never been an issue about wanting to see her or be around her. The parole condition can be added to stay out away from that building. I probably won't even drive down Howell Street anymore. That because of those precautionary measures that was set up, which if I do violate, which would make a felony, as far as it won't be misdemeanors if I violate the protective order or if I violate the condition. So since these conditions are in place as we speak, and the frivolousness of the charges, which is a misunderstanding, which I can't argue, the alcohol has never been an issue with me.
If you are an alcoholic or were an alcoholic, you are an alcoholic today.
I don't use harsh drugs. I only smoke marijuana. And I had red wine the previous night on Wednesday because I thought I was going to get remanded Thursday for what I was hearing about the incident at Sierra. I didn't get remanded. I got remanded the next day. I reported knowing that I figured that that's why they called me in, because it's back-to-back days. I didn't run. I didn't hide. I was expecting them to come to the Roger House and get me. I drove there. I left my car right outside the Grand Avenue parole place. No, they didn't care about that. And I just wanted, if it's possible, to be able to go home, make bond, go back to work, doing what I was doing, and fight this case and get it probably eventually nollied or whatever.
Mr. Rice, I just have one question for you. When you were asked for the search, where were you? Were you still at the halfway house?
No, I was in the parole building on Grand Avenue.
You were in the parole office?
With my back face against the wall and cuffed like this behind my back with an officer here and an officer here and the state trooper reading me my rights. After he read me my rights and I heard the charges, which was stalking third and all that, I had a panic attack, which I do have a medical condition because I was in Northern for 12 years, which is solitary confinement. I didn't get out of that building until my lawsuit helped me get out because they were holding me without justification because I've never been a physically threatening prisoner. Like, I have a bunch of tickets because I argue my case or I practice civil disobedience. If I'm going to SEG unjustly, carry me to SEG. I'm not walking. If I do something like get in a fight or say something crazy to somebody, I gladly walk to SEG. But whenever they use their authority in an abusive way, my only form of protest was civil disobedience, which I even did at the Grand Avenue parole office. And the police and the ambulance had to come because I was having chest pains. But I only did that because I can't do anything else. So it's like when the charges was read to me, Mrs. Saunders, I got hypertension. I take medication right now. So, I'm back on that because I can't sleep without it in jail. I'm 40 years old. I'll be 49 in July. I need this job. I've been doing this job since July. 6 months. I went from part-time to full-time. I had $3,000 saved with Roger Emerson House. I got a bank account in New Haven Savings Bank on Whaley Avenue. I had things in motion. I helping my mother out. I have a daughter that I'm just finally getting to know who's in D.C. I can't afford to just be sitting in jail for charges like this when I'm not a threat to society, when I'm not showing any criminal activity. This is just a misunderstanding that unfortunately, I can't even argue it with you today because a judge supersedes whatever power you have. So all I'm saying, if you do have the power to consider releasing me so that I can make bond and even wear a bracelet for a time period, I will do whatever y'all want me to do. I just want to go back to work and save money and continue doing what I was doing. That's all I want to do. I am not a threat to no one, Ms. Saunders.
Thank you, Mr. Rouse. I'm going to take a moment before I announce my findings, okay? Okay, Mr. Rouse, we are back on record. So I just want to, before I go into my findings, I just want to make it known that I did hear your argument regarding it not being serious enough, especially in regards to the do not release and you being on the $25,000 bond. I heard that when you said your job can make your, the bond for you. So, and I just want to make sure that I let you know, I did hear everything you said today. So with that said, I'm going to go into my findings. Regarding charge 1, as I said, probable cause was already established. I'm just doing this for the record. So no testimony was taken into consideration for charge 1 because probable cause was already established by a judge of the state of Connecticut Superior Court. Charge 2, search. I make a finding of probable cause based on your testimony today, as well as state's exhibits A and E. On charge 3, no consumption of alcoholic beverages. I make a finding of probable cause based on your testimony today, as well as state's exhibits A, E, and K. I find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. So this does conclude the preliminary hearing.
This is bull. Them are not serious charges of violation because they couldn't go. When I was laying on the ground, they could have went in my sneakers. What do you mean? They could have went in my sneakers when I was laying on the floor. It's not about that. You know that. I wasn't kicking. They had ample opportunity to go in my sneakers. I sat in there for damn near 45 minutes waiting, being checked by medical and all of that. That's 2. And then 2, alcohol, that's not even nobody gets violated on 1 alcohol consumption ticket. Nobody gets violated on that when you're outside. So why is that violation now? Why is that a violation now?
Your preliminary
No,
hearing.
that's bull. You're doing that for Miss Harris. All y'all work together. Y'all don't do nothing for us. Y'all don't do nothing for our people. All y'all do is want to keep us in jail because y'all some bunch of house. That's what y'all are. Frankly, that's all y'all are.
You are trash.
Y'all like seeing men, all your own men suffer. Look, you probably a lesbian yourself. Ain't you? You don't like men either. All y'all like that. All y'all don't give a fuck about our lives. I'm sitting in jail for some alcohol and because they couldn't search my shoes. Are you kidding me? Are you kidding me? I got a frivolous charge of a $25,000 bond, which is nothing.
No parole for
You're
Tate.
all pieces of shit.
None.
Take that, bitch.
Okay.
Mr. Tate is not getting parole because of anger issues. That's what's going on here. No parole.
And there you have it. And I just don't, you can't make this stuff up. When you think you've seen it all, you see something new in Connecticut, and the joke is, don't drink the water. Because what's interesting is we just don't see these type of hearings in other states. It's in other states you get them once in a blue moon, less than even 1%. But in Connecticut, it seems to be happening all the time. And I've thought about this, and either it's the water or maybe it's possible that you have these act outs because there's no CO in the room. In Louisiana, you have a CO. Oftentimes you have the actual warden sitting right next to the person. In Utah, you have correction officers there. I mean, it's but you just don't see that. In Iowa, you have someone sitting, but in Connecticut, this kind of result, or again, it might just be the water. But I think to sum it up, and Holly has in the notes here, he basically said he it seems that he gets charged for stalking. He's like, oh, I don't, that the stalking thing. I wasn't stalking her. I never contested it. And then I only drank, red wine because I knew that I was going to get in trouble. So I was just doing that. And it's like, I don't know. I don't know what to say. You know, he talks about his long record, and then he has a history of representing himself. And we do see there are certain type of people that I think their narcissism. It's so wow that they just cannot see themselves for what they are, which is, and instead, you know, he thinks that he's the whole world's out to get him, and he's doing. And keep in mind, this outburst that he just had, he has another hearing coming up. This was a preliminary hearing to see whether he should have another hearing. So he's going to have another one, and he couldn't control himself here. They still haven't decided how long they're going to reprimand him for. They might give him a bunch of years. It might just be 3 months. It might be almost time served, but I don't think it's going to help him with that kind of outburst. And if you haven't, look, I think that it's going to come any day now, but I'm first going to ship this hearing, and then when the next hearing, the follow up comes out, I'll ship that one, and if it's ready, I'll put the link in the description. It'll also be in the playlist, the return of playlist, so you can go and check that out. It's very possible by the time you're seeing this that that's going to be ready. But let me share with you the part where he represented himself for being a bank robber, because it's comical. It's so comical. Thank you, Holly, for pulling it up. So here it is. Jury convicts man who represented himself of robbery charge. And this was 2008. So you know he's like you said, he's done time for many. He's got out and reoffended, and but okay. So jurors convicted a New Haven man who compared himself to the New York Giants taking on the New England Patriots. Yeah, so what was that? What we were saying about narcissism? Oh my gosh. As he represented himself on attempted bank robbery charge, Daniel, who faced up to 25 years in prison, vowed during his trial in Bridgeport that he would take on the legal community single-handedly. But the 31-year-old had no comments this week when 6 jurors found him guilty of attempted first-degree robbery and criminal possession of a firearm in November 2006 incident. I'm surprised he had no comment. You would think he would have had a comment. Riles fired his court-appointed attorney at the beginning of the case and decided to represent himself. He started by asking prospective jurors. This is how he goes. Can you imagine? I mean, I can picture it right now. I really can picture him saying to the jurors what they thought about bank robberies. All said that they did not support them. He was like, what was he caught off guard? Like, oh God, I wasn't expecting that. And then, well, how about attempted bank robberies? I just got him. And no, Riles did not testify in his own behalf, but suggested during closing arguments that he had been set up. Then he admitted a surgical mask and gloves found in the getaway car were his. And it is always interesting when you testify on your own behalf, because you can't ask yourself questions. I mean, it's like, anyways, he was arrested after allegedly demanding $20,000 from a Chase bank manager at gunpoint. Can you imagine how much? I'm not even quite sure how much total time he got, but I don't think that much, because he had. I can go check this out later, but he has his next charge after that. His next one is 2022. So maybe he did 10 years on this. Actually could have done 12 years. So bank manager at gunpoint. The manager said he was going to get the money, but instead ran to a back room and locked the door behind him. Friend Robert Lee said that he gave Riles a ride to the Bridgeport, supposedly to drop him off at a home of a former girlfriend who lived near the bank. But when Riles came back to the car, he told Lee that it didn't go so well. Lee said Riles confessed that he had tried to rob the bank. Lee said he ordered Riles to get out of the car and drove away. So he's like, I tried to, and his buddy's like, get out of my car. Police pulled over Lee as soon as the officer said they found a surgical mask and gloves with Riles' DNA. Lee was charged in connection with the robbery attempt but that charge was later dropped. That's his co-defendant, I guess. The guy who drove. Police arrested Riles at the New Haven apartment a month later. It's interesting it took them a month to arrest him. I don't know what the big deal is, he allegedly told police. At least I didn't sell any poison to my own people or hit someone over the head and take their money. That's what he tells the police. I don't know what the big deal is. And I think you can still see that he didn't, even in the trial, he tells the jury, what's the big deal? And it's like, dude, you went to a bank with a gun. Like, we've seen enough of that. You traumatize we have seen people, we have seen so many parole hearings, and it's like some people can never go back to work. It alters their life. It changes their perspective. It takes away their peace, and he doesn't get any of that. Sentencing is scheduled for March 26th. It was a very conscientious jury which carefully reviewed the evidence before determining Mr. Riles was guilty beyond a reasonable doubt, said Senior Assistant State's Attorney Robert Brennan. Riles claims that as a result of his legal prowess, he has taken on a number of legal clients at the Bridgeport Correctional Center. Yes, his legal prowess. As we can see, he is quite the attorney. And again, we can go back to the Abraham Lincoln line that what is it? I forgot it again. The man who represents himself as a fool for a client. And again, that couldn't be any more true here. And with that, I'll let you go.
We are the parole board.
I'm not getting eligible for parole because I have
You need
injury.
to listen when we're speaking, Mr. Tate.
No parole for Tate.
Okay?
No parole for Tate.
So,
No parole for Tate. None.
okay.
Mr. Tate is not getting parole because of anger issues. That's what's going on here. No parole.